All right, everybody. So we were talking about time is of the essence. And we said it's a drop dead date. And if if time is of the essence is in the contract and one party or the other doesn't meet that date, the party who doesn't meet it is in breach. Right? Let's go ahead over to page 266. And let's look at the breach of contract remedies, since we're talking about breach. So I mentioned to you the remedies, according to the sales contract form 2T that most realtors use, and by the way, it's only for realtors or realtor affiliates, but that contract does say these remedies are for the buyer. And the contract does say that earnest money deposit is the only remedy the seller has if the buyer were to breach. But regardless, we need to know what they mean. And so breach of contract is violation without legal excuse. Someone's just breaking their word, their promise, they're backing out for no good reason. And so the non-defaulting party who is injured has recourse. And the first one is compensatory damage. Compensatory damage means compensate me. And it means a little bit more than that, actually. It means reimburse me for what I spent. Compensate me, make me whole again as if it never happened. In other words, I don't know if you've heard the terminology status quo ante. Status quo ante means before. Put me back to status quo as if this never happened. And so reimburse me. So think about it from a buyer's position. Offer gets accepted and we go under contract. The buyer's going to start spending money right away. They're going to go to the bank if they need a loan, and they will pay the appraisal fee. Usually that's paid in advance, and they'll pay for a credit report. If they want to do a home inspection, the inspector's going to want to be paid before he does that work. So the buyer is spending money. If the seller were to breach, compensatory damage means pay me back for what I've spent. Put me back to zero, back to where I was. Does that make sense? Okay. Liquidated damage is a little bit different. It's money damage as well, but liquidated, we're on 266. Liquidated damage is monies that you already negotiated. So liquidated damage would be like the earnest money deposit, for example. When offers are written up, all the blanks should be filled in one way or the other, and it could be a zero or it could be NA if it's not applicable, but the blanks need to be filled in. If the buyer is making an earnest money deposit, you will fill in the exact dollar amount. So that exact dollar amount is called liquidated damage. That's what you know you will lose, minimum. Security deposit is liquidated damage. If the renter damages the property above ordinary wear and tear, we know for sure that liquidated damage is what they're going to lose. Maybe more, but that for sure. Is everybody with me? So liquidated damage is a pre-negotiated number. Everybody knows what it is. All right, so you don't have to go determine it. You don't have to go look for receipts or anything. It's already been predetermined. The next one is the punitive or consequential. Now that one might be a little harder to get, but it's kind of like you intended to breach it. We want you to pay for that. You know, it's kind of like punitive damages you might hear in the court of law. You're going to pay the consequences. And then we know about specific performance. We learned that day one, didn't we? The buyer can say, sell me this property because I cannot replace it. It's so unique, I cannot replace it. And we know in North Carolina, the courts tend to favor the buyers on that. Everybody good? And then the last one at the top of the page, 267, is talking about rescission. Now, we learned about rescission in Chapter 2. Didn't we learn about the 5-day rescission on a timeshare? Didn't we learn about the 7-day rescission on brand new condo? And did you learn about a 3-day rescission in Unit 7 or 8? There's a 3-day rescission for the buyer, for, it's the residential property disclosure statement. Did that come up in Unit 8? The residential property disclosure statement and homeowners association disclosure statement, the buyer is supposed to receive a copy of that before they make an offer, because it's like a questionnaire. How old is the roof seller? The seller's supposed to answer the questions so the buyer can see it before they make an offer. If the buyer doesn't get that before they make an offer, they got 3 days to cancel the contract.
And it's called what 3 days or?
It's the residential property disclosure statement. Lord, are you mad?
Oh, man.
Oh, we don't want you to-
I'm good though. I got the insurance.
Okay.
Commission, everything.
I
Whoa.
know.
What?
That was someone else.
Oh, my God.
Don't laugh, he's having a
No,
horrible
it's not.
day. What's wrong?
Yeah.
Cameron.
I was kind of hit and then I spoke more.
Cameron, we'll make it right if we need, we'll help you on that if you need to.
I will take an A on the final exam. As a matter of fact, I'll go with a B.
It sounds like he says, I want my eggs over easy, I want bacon, I want.
It was just one.
Okay, let's go back, if you will, to page 264, beg your pardon. 264. You do need to know some terms called assignment and novation. Nova means new, everybody. You know what, I remember that in fourth grade, we were talking about stars, and they talked about a new star forming, and I remember that word nova. That's weird, because that's been 60 years, well, it's been a long time ago. Things stick. But anyway, nova means new. Assignment means carry it on. Assignment is stepping in the, carrying on the terms of the contract. Assignment is replacing a person and they take on the responsibility. I visualize an assignment as a relay race. You know, where you're passing the baton, you're just keeping it going, aren't you? An assignment is someone steps in and takes over the responsibility of the contract. The sales contract form that we're going to look at on Wednesday is not assignable, of course, unless the parties agree. If you had a test question and it was just straightforward, is contract form 2T assignable? The answer is no. They just said, is it? No. One person can't just say, I want to assign it. It has to be mutually agreed. So in other words, there should be more to the answer or more to the question. Is everybody with me on that? I'm finding that I'm saying that a lot. And now that we're taping the class, I need to not say the same things over and over. I need to say another thing. Are you getting it? I think of something else to say. Novation means new contract. Novation means maybe the buyer and seller are in this contract, and maybe the buyer went to apply for an FHA loan that we'll talk about next week. FHA, the appraisal is trickier, is more strict, and FHA, the lender might say, because the appraiser told them, that house really needs to be completely painted, they've got to do all of this, and the seller can't afford to do it. And so if the buyer still wants the property, the buyer might say, well, I can go get another kind of a loan. In other words, you need to draw up a new contract. Right? You're not going to go in there and start, I mean, it'd be better to draw up a new contract. Or it could be, let me give you an example. We had a rental house over near the college, and we had a couple of college students renting. One of the girls called up and said, I need to move, so I'm not going to be on this lease anymore. And she said, but I have a friend who would like to step in and take over my lease. Will you let her? And that would be called assignment, right? And we said no, we would prefer to have a whole new lease. That would be novation. It doesn't mean we're going to change the terms of anything, we just want to start all over. Because when you have assignment, the person who stepped out is basically still responsible. It's almost like you co-sign for somebody, not the same thing, but it feels that way. If you want to go borrow money, but you can't prove the income, and the lender says you need a co-signer. A co-signer means if you don't make the payment, they're responsible. And so that's what assignment does. If you transfer the responsibility to somebody, you're not off the hook. And somebody might say, I want to be all out of it, so let's do a whole new contract. So that's what novation is in assignment. Page 265, discharge of a contract. Well, discharge, let me give you another word for discharge. Why don't you write in there terminate? So this could be termination of a contract. Didn't we see in Unit 7 termination of agency? We saw in Unit 8 termination of agency contracts. So termination means it's being discharged. And one good way is to do it, fulfill it, close out the deal. That discharges it, it concludes it. By the way, I've had students say, terminate sounds bad. It sounds like something bad happened. Terminate could be everything worked out. The contract is over, that's what it means. And it could be breached, it could be canceled, or the parties can mutually agree, couldn't they, to let each other out. The law could say it can't be done, or it could be impossible to be done. So there are ways that contracts can be canceled or discharged. Look at the top two, partial performance and substantial performance. Let me just give you my examples. If you are having your floors redone and you tell the finisher, you show them the stain you want on your hardwood floors. And so they come in and do the work, and you come in after it's done, and it's not the shade that you picked out. Guys, that would be called, would call that either partial or substantial. Let's call it partial just for my example. Technically, this whole contract didn't get fulfilled, did it? Because it isn't what that was requested. Let's talk about, that might be more substantial. They did the floors, but it's just not the right color. Let's put that substantial. Partial performance would be, what if a buyer and seller are in sales contract and the seller agreed to put on a new roof prior to closing? And we've been through this hurricane and they can't get the roof on. They did everything else, but they couldn't get the roof. That's partial performance, isn't it? I'm not even going to call it substantial. The roof needs to be done. Well, the buyer could say, you know what? You didn't do what we're supposed to do. We're not going to close on the sale. Or a good way to do it would be ask the lender, we want to go ahead and close and the roof needs to be done. Can we ask the attorney, whatever the cost of that roof is, can we have him hold the money in an escrow account so we know the roof will be put on? Because after the fact, after the property is closed out, getting a repairman back in is a little harder to do. If you're holding their money, it's more enticing, isn't it? Alrighty. General rules for interpreting contracts. Look at the bottom of 265. Preliminary negotiations are not going to be enforceable. You know, it's going to be what is the final rendition or what is in writing. So in other words, you could talk over the phone, for example. If an offer comes in from a buyer's agent and you're the listing agent and you present it to the seller, and you and the seller talk about the earnest money, let's say the earnest money is $500. Let's say the house is listed for $200. $500 seems a little weak for a $200,000 house, even though there's not a formula. And so you're talking to the seller about it, and seller, how do you feel about it? Because I'm not saying the buyer will breach, but if he does, that's all you get. How do you feel about that? And the seller says, well, I think I have to have more, don't you? What do you think about $1,000? Before we counter this, before we change it, before we reject it, let me call the other agent. I'm going to preliminary run it by them. I call the other agent and I say, the seller is worried about the earnest money deposit. If we change it to $1,000, do you think it'll kill the deal with that? Or does the buyer just not have the money? Because the offer is presentable, the earnest money is bugging us a little. if we, guys, there's nothing wrong with having that discussion over the phone. It'll save time, wouldn't it? Instead of changing and taking and bringing it back, it'll save some time. If the agent says, I don't think that is an issue, then we know on the seller's behalf, if we change that, which is a rejection of the 500, isn't it? And it's a counter, then it doesn't mean what they said is going to happen, but we're feeling a little bit better. But that phone conversation's not binding is my whole point. All right, next page. The contract is treated as a whole thing, and like I said, we've got 13 pages. It's going to be interpreted as reasonable. You know, the words are going to be reasonable, hopefully, and ordinary. The written word is going to be is going to rule.
What page are you on?
266.
Thank you.
I hadn't had that question in a while.
Sorry.
Where are you?
But I just couldn't find you on the page.
Up top. 266 up top.
Thank you.
Okay.
I got you now.
And then you don't want to be ambiguous or gray. You know, you don't want to have elusive kind of language. It needs to be understood by both parties. Page 267, the contracts, the sales contracts. Look at your third paragraph on 267. There's another rule. Everyone, Jose came up to me, he was looking at his reading schedule, and the reading schedule on Class 18 says License Law Appendix A. Appendix A, let's look at it real quick, if you will. Go to page 615. 615, License Law and Rule Comments. This is Appendix A. And they're about 22 pages, and if I were you, I would start looking at it if you haven't already. For example, we did talk about some of this the first day, about who needs a license. We talked about that, if you remember. But if you go over to page 618 and 619, you read in Unit 7 about material fact. And Yasmin might have mentioned to you it'd be a really good idea to come back here and look at these examples. It will help you. And then if you go over a couple of more pages, more examples, if you go to page 624, this will be helpful if you look at the general brokerage provisions. In your right-hand column, it says agency agreements and disclosure. Guys, this is about agency and working with agents brochure. So this is another place to read it, but this is where the commission rules are. My whole point to you, again, we're talking about rules as we go, but you can also be looking back here as you go. It will help you, I think, because we're going to look at this section specifically when we get later in the course. Now back to 267. We are not allowed to draft language, Rule A11. We're not allowed to prepare documents for others, I'll add. We're not allowed to give legal advice. And so the forms that we're going to use, the realtor forms, have been run by the Realtors Committee and somebody from the Bar Association. So when we're filling in the blanks, we're not practicing law. But when you fill in the blanks, you need to do it succinctly. You don't need to write up a whole bunch of stuff because that could be interpreted as drafting without a lawyer's license. And they bring up the forms. I want to remind you, the commission does not make us use certain forms, these contract forms. They're not pre-printed by the commission. These are realtor forms. And it's up to your company if they choose to use the forms or not. But everybody, we're educated on the realtor forms, and it is way beneficial for realtors to use the same forms so that when we get offers, we don't have to study what is written in that offer so much if it's different. So if we understand the forms and we've all used them, it sure makes it easier. Page 268. talking about auctions, you've got another commission rule there, and I believe we might have even seen that at the beginning of the course, that an auctioneer of real estate must have a real estate broker's license plus their auctioneer license. An auctioneer of personal property doesn't need a real estate broker license, right? Auctions are held with reserve or without reserve. With reserves means it can be stopped. You know, it's not reaching the number, doesn't look like it's gonna reach the number that we need. Without reserve means it goes to the high bid. Everybody good? The other thing is, when the auctioneer says sold, it is sold, because the auctioneer represents the seller. All right. When I've got you homework, Wednesday morning, let's talk about Wednesday morning. Wednesday morning, we'll go over that the answers to 7, and Wednesday morning, we'll look at that math solutions that I gave you.